Hello, this is Marjia Mustafa. My student ID is 24697. Today we are going to present about the case Canada versus Australia, measures affecting importation of salmon. I'm going to present the background of the dispute and the brief facts of the case. The dispute was between Canada and Australia about importation of Canadian salmon in uncooked form into Australia under Australian quarantine restrictions. Here, the complainant was Canada and the respondent was Australia. And today we're going to present Canada and support them in our case today. And we all know the product measure at issue was the restriction from Australia for Canadian salmon, and product at issue was fresh, chilled, or frozen Canadian and other type of salmon. Here, Canada had complained to the WTO, World Trade Organization, against Australia's quarantine restrictions and the measures used to prevent the commercial importation into Australia of fresh, chilled, or frozen Canadian salmon under quarantine Proclamation 86A of 19 February 1975 and its modifications. Before the promulgation of QP 86A on 30th of June 1975, Australia did not put any restriction on the importation of uncooked, wild, adult, ocean-caught Pacific salmonid product. However, they had no restriction on cooked or ready-to-consume production of salmon into Australia. Canada also was arguing on the matter that Australia's argument on the ban was based on the health grounds to prevent disease into fish stock in Australia without being on a risk assessment and without sufficient scientific evidence. Canada also claimed that Australia's such action contravened the agreement on the application of sanitary and phytosanitary measures, which is SPS agreement, and specifically articles 5.1, 5.5 and 5.6 of the agreement, as well as 2.2 and 2.3 of the same agreement. For such action from Australia was inconsistent. And also we found that articles 11 and 13 of GATT was also inconsistent, which is General Agreements on Tariffs and Trade 1994. Canada also argued about misapplication of principle of judicial economy by not making findings for all the products at issue, which were fresh, adult, wild, or ocean-caught Pacific salmonid product and other types of salmon. In particular, findings in respect of Articles 5.5 and 5.6 for other Canadian salmon by the panel as found by the appellate body. Thank you. My other colleagues will be explaining you in detail about the case, and they will also talk about the case in detail in terms of how they have contravened the articles of specific agreements. Thank you.
Hello everyone, my name is Shahil Khan and my student ID is EMV22121, and today we are going to discuss about my part, which is the legal issues presented in the Canada versus Australia on the importation of the salmon. So in this case study, being a member country of the World Trade Organization, both Australia and Canada are required to comply with the general agreements on tariffs and trade, and also the applications of sanitary and phytosanitary measures agreements as drafted by the WTO. So on these claims done by the Australian quarantine measures, Canada requested for a panel to be formed, and which was established in 7th March 1997 to investigate on the issues. So while the panel investigated the issues, they concluded that the Australian quarantine measures were inconsistent in regards to Article 2.2, 2.3, also Article 5.1, 5.5 and 5.6 as mentioned in the SPS agreement. However, Article 5.6 couldn't be open up much due to lack of evidence, but the rest of the four articles clearly indicated that the quarantine measures were the claims made by the quarantine measures were inconsistent. So, and also the articles 2.2 and 2.3 is based on the basic rights and obligations, whereas the article 5.1, 5.5, and 5.6 uh, are based on the determination of the appropriate level of sanitary or phytosanitary protection. So that's my part. Thank you. I would like my group members to continue with the further presentation. Thank you.
Hi, this is Vinita. My student ID is PPE2129. Today I'm discussing the individual parties' argument in the case Canada versus Australia, measures affecting importation of salmon. So Canada complained to World Trade Organization against Australia's quarantine restrictions and the measures used to prevent the commercial importation of salmon in Australia. Australia argued that the importation of fish or parts of fish are subject to treatment to prevent the introduction of any contagious disease or disease affecting person, animal, or plants. Canada requested access to Australian market for uncooked salmon. As a result, Australia conducted an import risk analysis for ocean coast Pacific salmon. However, Canada claimed that this category of salmon, which was the basis for the risk analysis, should be distinguished from the other categories of Canadian salmon. As an exporter, Canada explained that Australia's action contravened the agreement on the application and sanitary and phytosanitary measures, that is the SPS agreement. And now I would like my group members to continue with the group presentation. Thank you very much.
Hi, my name is Vishal Rana. Today I am going to present in front of you the traditional tribunal decision of the dispute salmon case between the Australia and Canada. The panel emphasized the three requirements that were set down already by the appellate body, which are fundamental, establish a risk management. The panel also noted that a rational relationship between risk assessment and measure should be present for measure to be based on. And the second one is the panel came to a conclusion that Article 5.5 was not violated by the Australia, as it was found that in spite of the fact that Australia was utilized various degree of protection to various yet adequately to the corporate conditions. And third one is, and last one, Australian measure consideration the three components expected to the exhibited an inconsistency was using Article 5.6. The panel noted that Australia had acted conflicting with the Article 5.6. The panel found that considering the economic and technical feasibility of alternative measure. Thank you.
Hello everyone, my name is Sarishma. My student ID is EMB20138 and today I'm here to present about the significance of the case Canada versus Australia, measures affecting importation of salmon in international law. International law basically is an appropriate rules and regulations set for handling international trade. It just makes sure that international trades are being ran smoothly. There are no issues in international trade. The World Trade Organization has some rules for international trade. WTO rules are codified in three agreements. Three agreements are General Agreement on Tariffs and Trade, covering international trade in goods, the General Agreement on Trade in Services, and the last one is the Agreement on Trade-related aspects of intellectual property rights. After analyzing the case, we can conclude that on 18 May 2000, following the panel's decision and following decisions between the World Trade Organization and the government of two countries, sectors of each government and the panel, Canada announced that it had come to an agreement with Australia to bring the dispute to a close. Both the countries exchanged letters detailing the agreement, and the agreement stated that Canada would monitor closely Australia's commitment to implementation of the agreement, and the agreement became effective from 1st of June 2000. By saying all this, I would like to conclude our presentation. Thank you for watching.